In this video, the main case law of the European Court of Human Rights on the recognition of same-sex relationships will be discussed. In 2010, the court ruled in a case against Austria that the right to marry, enshrined in Article 12 of the Convention, did not entail a right to same-sex marriage, nor did the right to privacy and family life of Article 8 of the Convention. The court came to that conclusion through a reasoning based on European consensus, which is an important concept in the case law. This can be seen in other cases as well. For instance, the cases on gay propaganda laws against Russia, where the Strasbourg court did not accept the protection of morals or of national sensitivities as a justification to limit fundamental rights. In those cases, the freedom of expression. The court there noted, quote, "A clear European consensus about the recognition of individuals' rights to openly identify themselves as gay, lesbian, or any other sexual minority, and to promote their own rights and freedoms." End of quote. Because of that consensus, the margin of appreciation of the member states to ban so-called gay propaganda was limited. On same-sex marriage, however, there is no such European consensus. The court explicitly noted the, quote, "deep-rooted social and cultural connotations of marriage, which may differ largely from one society to another." End of quote. Although the right to marry does not exclude the possibility of same-sex marriage, it is left up to the member states whether to legalize same-sex marriage, yes or no. Nevertheless, the court's judgment in 2010 contained elements of hope. 1. The court suggested that if one day the European consensus would shift, if a clear majority of member states would support same-sex marriage, it might come back on its conclusions and rule the right to marry to encompass a right to same-sex marriage as well. 2. The Strasbourg court for the first time stated same-sex relationships to fall within the notion of family life, thus needing the protection of the right to family life as enshrined in Article 8 of the Convention. 3. Although the court didn't establish a right to same-sex marriage, it clearly hinted that it might have ruled in favor of the applicants had they asked for registered partnership, as it did note a growing European consensus in this regard. That question, whether the right to family life enjoyed by same-sex couples would encompass an obligation for the member states to provide a form of legal recognition of same-sex relationships, was gradually explored in 3 subsequent cases. In 2013, the legislation in Greece, providing for a system of civil unions only applicable to opposite-sex couples, was challenged in front of the court. A first victory for same-sex relationships was reached as the court ruled it a discrimination linked to the right of family life to exclude same-sex couples from the provided system of civil unions. If, and only if you provide registered partnership, the court reasoned, you should make it accessible without discrimination, particularly given the fact that same-sex couples have no alternative, as they cannot get married. In 2015 and 2017, the court went even further in 2 cases against Italy. Italy had no system of civil unions at all, so it was no discrimination of same-sex couples that the option was excluded, as straight couples had no chance of getting a civil union either. Nevertheless, the court ruled in favor of the applicants, basing itself first on a growing consensus in Italy and the opinion of the highest Italian courts, but later also on the growing consensus in Europe against Italy. Italy had to provide a system of civil unions for same-sex couples, period. Only if Italy would have brought up convincing prevailing community interests, the court might have ruled differently. The remaining question is, what does this mean for the other member states of the Council of Europe who don't have any form of legal recognition of same-sex relationships? No marriage, no registered partnership. The consensus reasoning in the cases against Italy gives hope for those supporting LGBTI family rights. The same reasoning of a European consensus could also be applied to, for instance, Russia, Ukraine, or Poland. The next cases pending before the court are against Russia. Marriage is another matter. Contrary to what is the case for registered partnership, where more than half of the member states have introduced a form of legal recognition, we're still far from a European consensus on marriage. The bans on same-sex marriage introduced in certain national constitutions might make it even more difficult to establish such a consensus. The European Convention on Human Rights functions as a living instrument. It is not to be excluded that one day, following a positive evolution in the member states, the European Court of Human Rights would also rule in favor of a right to same-sex marriage.